Welcome to an afternoon session of the 5th District Court of Appeal. We have one case on the docket this afternoon. I am Judge Carrie Ann Wozniak from Orange County, and with me today are Judge Jim Edwards from Seminole County and Judge Meredith Sasso from Orange County as well. The case we're hearing is 21-2372, Jade Eva Merriman versus Brian Uriel Adler. And each side will have 20 minutes to present their case. And Mr. Duncan, I believe you are counsel for the appellant. If you would like rebuttal time, please let me know before you begin your argument how much time you would like. You'll see a timer in the upper left-hand corner on my screen, and we will adjust that for depending on the amount of time you want for rebuttal. And with that, Mr. Duncan, you may begin.
Thank you very much. May it please the court. Good afternoon. I am Michael Duncan. I am counsel for the appellant Jade Merriman in this appeal. With your honor's blessing, I would like to reserve 6 minutes for rebuttal.
6 minutes. Okay, if the timer can reflect that. Okay, go ahead. I will stop you with 6 minutes. I apologize.
Thank you very much, Your Honor. Your Honor, we are here in a post-dissolution matter, as the court is well aware. This matter straightforward concerns an issue of contractual interpretation. The contracted issue, a marital settlement agreement between the parties. It was reached in, I believe it was 2018. And it concerned a number of things. Obviously, there was a parenting plan, which is not at issue today. But what is at issue in the marital settlement agreement is the resolution with respect to certain pieces of property in the equitable distribution, namely marital real estate, the Rybar, I'll refer to it as the Rybar Lane property.
And there is no transcript of the hearing, correct? On that for the order that's under review. Can you explain how that does not preclude our review of the order?
Thank you, Your Honor. And yes, as we addressed in our brief, it does not preclude review by this court because the trial court's errors are plain on the face of the record, on the face of the order. This issue, what is not at issue here is the fact that the trial court enforced the marital settlement agreement. What is at issue is the manner of enforcement, particularly the fact that the enforcement order contradicts and essentially rewrites the terms of the marital settlement agreement. That is plain on the face of the trial court's order that's being appealed here. And so all that is left for the court to do on review is simply review the marital settlement agreement that was to be enforced and the trial court's order. So the lack of a transcript does not preclude appellate review. What happened here, Your Honor, is as the marital settlement agreement spells out, my client, the former wife, was given was granted the marital residence, the Rybar Lane property, in the marital settlement agreement. She had 2 years to either sell it or refinance it in her name. She did not do that. That is not contested here. My client failed to do that. However, what happened then is the former husband files his motion to enforce and for contempt. And rather than simply enforcing the terms of the marital settlement agreement, which said that should the former wife fail to sell or refinance, the former husband could effectuate the sale or the refinance on his own.
Was there actually a finding of contempt? I don't remember reading one in the actual order.
Well, it seems to have found her in contempt because it granted attorney's fees, and that's my client's and my reading of the order is that it essentially found her in contempt along with enforcing because it granted the request for attorney's fees, and the only basis for the request for attorney's fees was that my client was in contempt. So in doing so, in other words, Your Honor, I guess for lack of a better term, while the court did not expressly say we find or the trial court finds Ms. Merriman to be in contempt, its actions in granting the request for attorney's fees essentially did just that. Further, and Your Honor, just following along with my previous statements, what happened here is the trial court in its order went well beyond and essentially added terms to the marital settlement agreement with respect to the dissipation of the marital real estate. It ordered not only that it be sold, but it ordered and dictated terms with respect to the sale. For instance, the husband was to select a realtor and that the realtor was to set the price with regard to the sales price of the property or the listing price. And it
Well, it
further
seems to me that was more of a clarification, because under the MSA, didn't the husband always have the right to choose the realtor and take all necessary steps to sell the home? So isn't it more of a clarification?
that Your Honor, respectfully, that's not a clarification of the order. Certainly, the husband had the right, if he was to effectuate the sale, I will agree with the court that the husband would have had the right to select the realtor. Okay, but in terms of dictating the terms of the sale, that's going beyond clarification. That's actually instructing the parties as to how they are to effectuate this transaction, and essentially its terms, its economic terms. But most critically, Your Honor, is the trial court's dictating or directing that the proceeds, the net proceeds and equity from the home be split between the parties. There's nothing.
Was there, go ahead. I think you're about to answer my question.
There's nothing within the marital settlement agreement, and if I may refer to it as the MSA, there's nothing within the MSA that directs that the proceeds or the net equity is to be split between the parties. In fact, the only term of the MSA that references the equity of the property or the asset itself is the provision that says that the appellant, my client, was to receive the marital home, and that the respondent, I think it was that the former husband was to have no further rights as to it. Now, granted, the MSA.
Would you agree that the distribution of proceeds from a sale, a contractual requirement for a sale, is something that would naturally flow from that contractual requirement? So in other words, if a contract requires a sale, and what is to be done with the proceeds is not included in the contract, why isn't that within the court's purview to determine that that's an ambiguity, because it's something that would naturally flow from a requirement of a sale?
Well, I guess to start with the last point, the ambiguity aspect, no party ever raised the issue of an ambiguity. No party filed a motion.
Is that clear to us when there's a lack of transcript?
Yes, it is, and here's why. The motion for enforcement didn't say, "Hey, Your Honor, hey, trial court, there's an ambiguity here. Please resolve this." The motion for enforcement that was filed by the former husband was very clear and direct. It said,
How do
"Hey,
we know, Counselor, how do we know that wasn't tried by consent? I mean, I can see the judge, since we don't have a transcript, going, okay, so wife, you're supposed to have sold the house. You didn't. Husband, now you sell the house. And by the way, what do we do with what's left over? We hope there's equity that's left over. How do we know that wasn't discussed?
well,
That's certainly a possibility.
then there would have been a finding in the order that there was an ambiguity. There would have been a finding or a finding by the trial court that there is an ambiguity here. Number
How do we know
one.
that? There's no requirement for findings on ambiguities. And even if there was, there's no motion for rehearing indicating that a lack of finding as to ambiguity needs to be made. There's lots of gaps here. So I think that goes back to Judge Wozniak's initial question. How do we analyze the substance of what I think you might agree is a very limited order? How do we analyze that when there's all these contingencies and we as an appellate court are required to assume that the trial court acted appropriately and consistent with the law?
Because, Your Honor, if if there was an ambiguity here, then there would have had to have been some indication on the record that there is an ambiguity. There's no the trial court did not say, hey, there's an ambiguity and I'm going to clarify the MSA this way. The trial court said, I'm enforcing it. He said, I am enforcing it. And he said in his order, I apologize. The trial court said in its order, the trial court is enforcing, and here's how I'm enforcing.
But how do we know that without the transcript? In the transcript, it could say the trial court found, oh, I find it a latent ambiguity and I need to hear evidence to decide what the parties intended. But we don't know that without the transcript.
I will concede that you don't know that without the transcript. I would state, however, that in instances of, for instance, mutual mistake or an argument of an ambiguity, I believe it is necessary to raise that by motion so that, number one, all parties are on notice going in, because we know from this court's previous rulings that where there is an argument of an ambiguity, which would thus give rise to the opportunity for the parties to introduce parole evidence, that requires an evidentiary hearing, and that requires advance notice. And obviously we have a situation here where, and this is raised with
Counsel, unless it's tried by consent.
Unless it's tried by consent, I will admit that.
We don't know, and that's that's the problem you have here. Again, I think it would be unusual if a court ordered a sale and asked, okay, what's to be done with the proceeds, and everybody kind of shrugs their shoulders. Judge, maybe you need to decide that. You need to figure it out, especially where the former wife wasn't paying the mortgage and now there was a foreclosure suit going on. So, I mean, without the transcript, I don't know how you get around the possibility that it was tried by consent.
Your Honor, again, if the issue is never, there's no indication on the record of any party ever claiming an ambiguity, and in fact, we don't even see it in the briefing that there's any reference to any claim of ambiguity. It's not there. And I understand the court's concern about a lack of a transcript. This does, though, touch a little bit on my client's argument with regard to the way the continuance motions were handled.
Let's talk about that for a second.
Certainly.
Your client made inaccurate, and that's being extremely kind, inaccurate statements about when she received the notice of hearing. In her first motion for continuance, she claimed to have gotten it a week after she actually got it. She claimed she got it August 30th when she actually got it August 13, which she did admit in her second motion. I mean,
she did correct that.
Well, corrected. She filed a statement that was just flat out wrong in her first motion and expected the court to rely on it. And there was a response to that first motion and the court ruled on it. Are you saying there has to be a hearing every time there's a motion for continuance?
The rules of judicial administration indicate clearly that it should be heard. I am not suggesting that it should always be granted. Certainly that's within the discretion of the trial court, Your Honor. But here we have a scenario where a request for continuance comes in, it's denied sua sponte. Request comes in again, and certainly acknowledging the inaccurate statement in the initial request with regard to when it was received. Both requests were very clear in that, from my client, in that while it was inartful, she did say that she needed time to prepare and she needed time. I believe in one of them, she made reference to attempting to find an attorney. And so it's not as though we were dealing with a significant period of time here. I believe the notice of hearing was sent out. I believe it was 2 weeks prior to the hearing itself. And certainly, Your Honor, our position is that she should have at least been heard on it. They shouldn't have been sua sponte denied. And when we're dealing with a significant issue such as this, a brief continuance certainly would have been justified. And I believe it was improperly denied.
So
So
you think it's an abuse of discretion to deny a motion for continuance that deals with your client's failure to pay mortgage and failure to pay car payments, which she was clearly aware of, with 2 weeks notice of a hearing? Do you have a case that specifically says 2 weeks notice for a hearing is insufficient, given
I
the
do not.
fact that the transactions are well known to your client?
no, I do not, Your Honor. And we're certainly not denying that my client failed to fulfill her obligation. But that failure of hers to fulfill those obligations contractually does not justify, first, the denial of the continuance requests without opportunity to be heard, and then followed by the trial court rewriting the terms of the marital settlement.
Counsel, you are into your rebuttal time, so you
I just noticed that, Your Honor. So if I could conclude, I'll follow up with my final conclusion and rebuttal.
Okay, thank you.
Thank you.
Ms. Geiger, you may proceed.
Thank you. Good afternoon, Your Honors. May it please the court, Stacey Geiger on behalf of the appellee Brian Adler. I'd like to start with the issue of a transcript and the appellant's failure to provide a record of the proceedings of the lower court. The burden, as we know, is on the appellant to provide that transcript or a permissible alternative to allow the court to review these proceedings that occurred on the trial court level. Without that documentation, we know that the arguments, we don't know what the arguments were advanced, what if any objections were made, what if any findings the trial court made on that record. Without the transcript or substitute, appellant is not able to show any error at all and therefore is not entitled to appellate relief. Without that transcript, there's nothing for this court to review beyond the terms of the MSA. We're left we don't know about testimony, discussions, arguments, objections, etc., any of that took place. So for those reasons, we request the court summarily deny appellant's appeal as to those issues. Although it is our contention that the lack of transcript precludes any review, obviously I want to address the appellant's oral argument, so I'll continue with the other issues. As to
on the lack of transcript, can you address whether you think that precludes reversal on the attorney's fees award specifically, since there was no findings as to?
Absolutely, Your Honor.
Yeah, go ahead.
So as to the attorney fees, the standard of review is abuse of discretion. In deciding an award of attorney fees, the court not need limit its consideration to need or ability to pay. The court must consider other factors such as the appellant's disregard of the court order. Here, her fees were appropriate based upon her misconduct. The appellant's written argument.
And I'm focused primarily just on the lack of findings rather than the merits of the fee award.
So yes, Your Honor. So
solely the lack of findings would justify reversal.
Absolutely, Your Honor. So it's our contention that without the transcript, he didn't note anything, or we're unable to determine what was said or discussed in that hearing. But the fact that he granted fees in a lower amount that was actually claimed in the attorney fee affidavit suggests that the court did in fact make factual determination of fees inside of the hearing itself that day.
Okay, so we have a case from our courts, Duke versus Duke 2017, that suggests that the failure to set forth specific findings on hourly rate and numbers of hours is error apparent on the face of the judgment that is reversible even when there is no transcript. With that being the holding, and I'm putting you on the spot, are you familiar with that case? And if so,
I recognize, Your Honor, I'm not familiar.
Okay. Just based on what I've told you, is there any reason to distinguish this case from those set of facts? So essentially, failure, it's a family case, failure to make findings on hourly rate and number of hours. Our court has said that that is error even when there's no transcript, although the award of attorney's fees would be affirmed.
Your Honor, my only contention would be that the fee affidavit was submitted. So the court did actually later, it was submitted after the order was entered. So it would stand to reason that inside of the hearing, it was addressed on an hourly rate and the actual hours had in those numbers. And then that's why the fee affidavit was submitted thereafter. Unfortunately, they're strangely being higher than the amount, which suggests that it, was discussed. So technically, I guess it would be in the court record, just submitted after and not incorporated into that order.
Counsel stated that his assessment of the fees is that was granted as a sanction for contempt. In your view, is there any other basis under which the fees could have been awarded?
As part of the motion to enforce, if we're going to separate them, there again, as this court pointed out, there was no clear-cut decision, as it was just an order granting. It didn't say as to contempt or as to enforcement, but there was clear misconduct from the appellant, which the judge did note, which resulted in this order for her failure to comply with the order. And part of those factors that would result in fees were found as a penalty to the appellant.
Ms. Geiger, Mr. Duncan seems to say that an evidentiary hearing, or at least a hearing, is required for every motion for continuance. Do you agree with that?
Not at all, Your Honor. One, I would think that would be a giant waste of judicial time, because I'm sure, as in this court, we actually filed a motion continuance as well previously. So if every motion was heard, it would not be in the best interest of the courts. But as far as the continuance in this hearing, there were many factors considered in reviewing a motion. Obviously, one being injustice as to the moving party, which we've already discussed. She had 2 years to comply with the final order, and then this wasn't even filed until 3 years in. So at this point, there's no injustice to the moving party. Whether the request of continuance was unforeseeable by the movement, I don't believe that that's even a question. And then whether the opposing party would suffer any injustice if the continuance was granted. And I think that's the major factor in this case, because the property at issue was in foreclosure. Both parties stood to lose a lot if the foreclosure case was continued and the house wasn't put on the market. There was no guarantee in any case where this is an issue. If a house is sitting there and it's in foreclosure, technically, I suppose the banks could foreclose at any time and move that case forward. Meanwhile, these two parties could completely lose out on any equity. So there was a sense of urgency. Time was definitely of the essence in this case. And the judge, having reviewed her motions, like you said, she had 2 full weeks prior to the hearing. She had 3 years to move to comply with the order. I don't think there was a question of any injustice or detriment to her. You can certainly, if there was an issue of finding an attorney, she had plenty of time to do that as well.
Speaking of equity, your opponent says that the trial judge rewrote the MSA to call for a split of the equity when, if you looked at it, former wife was to get the marital home. She was supposed to do things with it, like get it refinanced so that the husband would not be exposed to further financial obligation. but there's nothing in the MSA, is there, that really hints at a husband getting half of the equity?
No, Your Honor, and I think that's part of what we addressed in the beginning was the transcript. It is our contention that there's no question as to a plain reading of the MSA that the appellee, the former husband, actually acquired 100% of the ownership of the home. As to read Section 1 of the MSA, awards for the house, but the appellant is ignoring the fact that Section 5 was a condition subsequent, divesting the appellant of ownership of the house upon her failure to refinance the home. If the house was to go to him, or at least if she doesn't refinance, the options were that he move into the house and refinance in his own name or sell the residence. To find that the choices were open to the appellee while the appellant retained ownership makes no sense. That's just an absurd possibility. Why would the appellee move in and refinance a home that belonged to somebody else? Section 5 clearly transfers that interest to the appellee once those conditions were not met. So when he filed his motion to enforce, and again, we have no way of knowing what occurred during that hearing via testimony or any other evidence for reasons unknown to us, he was generous and wanted to give her half of that equity after removing his costs and debts. And again, no idea why he wanted to do that, but it was his choice. He had 100% of the equity. He could have given it to anybody that, or spent it any way he wanted. But for some reason, he only asked the court to grant half, which they did. That answer your question, Your Honor? I'm sorry.
Yes, thank you.
Sorry, we're jumping around, so I wasn't sure. Is anyone else? I can go back, keep going.
I don't have anything else.
I don't have any questions.
Okay, so just to sum up, Your Honor, it's our contention that there is no question as to the clear meaning of the MSA is that you can't separate Section 1 from Section 5. It awards the division of proceeds as requested by the appellee in his motion. The appeal should be denied due to appellant's failure to provide a transcript of the lower court's proceedings. The appellant should not be heard to claim the lower court did not make certain findings when she failed to provide a transcript that may reveal that those very findings are lacking, or that she claims are lacking. The denial of the appellant's motions to continue were proper. For those reasons, we request the appeal be denied in its entirety.
Thank you, Ms. Geiger. Mr. Duncan, your rebuttal, you have 4 minutes and 35 seconds.
It would help if I unmuted. Thank you very much, Your Honor. First, I want to address the attorney's fees issue. And I owe the court a bit of an apology. Judge Sasso referenced the Duke versus Duke case. And while it's one I'm familiar with because I've cited it in a number of different proceedings, I didn't include it in mine, although I believe I made the point in my argument with respect to the attorney's fees. There's a complete lack of findings. And while the submission of evidence and the submission of affidavits and affidavits being in the record, certainly those may be required by the trial court. The case law is very clear, not only in this in this appellate district, but in others, that a trial court in awarding attorney's fees from one party to another must make specific findings, and it failed to do so. And it's frankly glaringly obvious the fact that the purported evidence, the affidavit, et cetera, was submitted and filed after the hearing and after, not only after the hearing, but I believe after the entry of the order, is somewhat telling. I want to address and respond briefly to a point that my opposing counsel just made, and it confirmed my argument with regard, I believe, with regard to the issue of the possible ambiguity. There's never been an argument about ambiguity. The opposing counsel has always taken the position, the appellee has always taken the position, both before the trial court and now here, that the MSA is unambiguous. Section 5 in nowhere divests the appellant of ownership, any ownership interest in the property.
But it allows the former husband to move into the house and stay there forever, doesn't it?
Correct? Correct. And that's, that happens.
Or to sell it.
Or to effectuate the sale, certainly, but it doesn't say anything about the ownership. And that's critical. There are many other examples in real life and in the law where, for instance, life estates, the granting of a life estate, an individual can have an ownership interest, but somebody else can have a lifetime interest in the property and take possession of it. As to why the former husband would sign an agreement like this, well, let's face it. This court has said in Gray versus Gray and many other cases that the fact that this might be a bad deal or an improvidently or improperly written or unclearly written agreement, it's not the job of the courts to come in and rewrite it. And as to why the former husband would have signed off on this, I don't know. Perhaps he just wanted to make certain he got his name off the mortgage. Frankly, we see that oftentimes in dissolution cases. The right to come in and require that the property either be refinanced or sold or in some way have somebody's obligation on a mortgage removed. But that doesn't divest somebody of their ownership interest. And that's what happened here. And again, if we look at the very clear words in Section 5 of the MSA, nowhere does it divest the wife of the ownership interest in the property. It certainly divests certain control if she doesn't meet her obligations, certain control over certain control over certain activities, but it doesn't divest her of ownership. And that's what happened here. And that was wrong. The appellant respectfully requests reversal, certainly to address the attorney's fees issue and to address this issue with regard to the proceeds from the sale of the property. Thank you very much, Your Honors.
Thank you, counsel. That will conclude this session of the court, and the court will be in recess.